Happy New Year. Well, for the immigration purposes, October 1st is the new year. Emily, what do we have news for the new year?
Yeah, with October 1st, a lot of stuff happens in immigration. We have the new visa bulletin, H-1Bs take effect. We also have maybe the new $250 visa integrity fee that was part of the One Big Beautiful Bill Act. So we'll talk about who pays it, when do you pay it, do you get it back, how do you get it back, can you even pay it right now? And then also, because October 1st is the beginning of the fiscal year, that means today, September 30th, is the end of the fiscal year and the end of our current budget. At this point, what happens if there's a government shutdown because they can't agree on the next budget? What does that mean for non-immigrant visa holders? And then we wanted to give an update on where we stand with the $100,000 fee for H-1Bs that was announced 2 Fridays ago. That presidential proclamation. Who do we know for sure it applies to? Who's still unclear who it doesn't apply to? And lastly, we have more action on the birthright citizenship case. Another presidential proclamation that goes back to January 2025. And where does that stand with the Supreme Court? When might we get an update or a decision on it? And what's at stake now for visa holders?
Emily, so this $250 is applicable to all visiting visas or all H1, H4s, or every non-immigrant visa that will be applied for?
Appears to be every temporary visa. So every non-immigrant visa, student visas, tourist visas, business visas, work visas, everybody, except for visa waiver and Canadians who don't need visas.
So those people like Europeans who come on visa waiver, and for Canadians who come on visa waiver, Japanese or South Koreans who come on visa waiver, this is not applicable for mostly for Indian nationals, Chinese nationals. Most of the other nations, Mexico, Philippines, they're all subject to the $250. Is it per family or is it per person, though? Let's say my wife, and I have two kids.
Yeah, it's $1,000 then. Unfortunately, it's per visa issued. So if you have 4 people applying for visas, 4 people are going to have to pay it.
So they said that I can get the refund of the $250. So as soon as I enter into USA, I get refund. I went back to USA, I get refund. How do the refund process work?
Nobody knows, I don't think. DHS is supposed to reimburse, but it's after the end of the visa validity period. So if you're coming on an H1, H4, that's valid for 3 years, the earliest you could potentially get reimbursed for this is 3 years later. So we don't know what that is going to look like. We don't know who to apply to, what you have to submit in order to get it. What if you apply for an extension within USCIS? You're still complying with the terms of your visa, but does that mean you lose out on getting your $250 back? Lots of unanswered questions on it right now.
Is it mandatory for the company to pay an H-1B or employees can pay?
I think anybody can pay. As far as I am aware, there's nothing requiring the company to pay for it. So it's similar to the visa application fee or the MRV fee, except with this, you pay for it after the visa is issued rather than paying those other fees upfront for the actual application process. So if your visa gets denied or you get a 221G, at least you don't have to pay it until the visa actually gets approved.
Oh, wait a minute, Emily. I'm crazy thought in my mind. It looks so complicated to get the money refund. Well, it is complicated to get the H-1B. So we hire lawyers like you, me, and other people in our office, and they cost more than $1,000 to get a H-1B, and of course, filing fees and all those different things. You mean to say to get $1,000 back, you have to pay the more than $1,000 to the lawyers?
I have no idea how this is going to work, what the process is going to be, whether it takes an attorney to do it. It's entirely possible that it's not worth trying to get it back. I think the whole thing is kind of useless in the first place. I really don't know why they felt the need to create this fee, a refundable fee, because most people who are on work visas are complying with their terms of their visas. So why do we need to make everybody pay an extra $250?
What Stephen in his national channel, our other business partner, Stephen Brown said, Emily, is that this probably is bad for the people who wants to legally come in United States. And for those people who wants to come and stay here illegally, probably they can afford it easily because for them it's not a problem. For the people who want to stay, for the legally binding people, it's a burdensome to pay. For example, somebody wants to come to visit the Disney, they have to pay $1,000 for a family of four people, and when they go back and they need to hire a lawyer to get the 1,000, which they're not going to use that. So the people who want to come here and probably work illegally, for them probably they can pay, I guess, but not for the legally people. That's what Steven said. That looks to be more appropriate. This sounds very damaging to the people who are coming legally in the United States. I mean, that's the way I take it.
Yeah, I agree.
Emily, what is this government shutdown? Now, New Year starts all of a sudden. Is negotiations are going on between Democrats and Republicans. They need 60 votes in the Senate. Looks like they got 53 votes. 7 Democrat senators are needed for them to vote in their favor so that the government doesn't shut down. And we have been through this government shutdown. I've been at least from for a long period of time, from 1990 fight right now. A lot of shutdowns, though. What does this shutdown means, though? Does it means that we can't enter into the country on any non-immigrant visas? We can't file the H-1Bs. We can't file the change of status to B2 applications, or we can't file the perm labor certifications and I-140s. Can you explain if the government gets shut down? What are the things that will work according to you? What are the things that may not work?
Yeah. The biggest thing that gets impacted is the Department of Labor because everything we file with them for immigration purposes is free. There's no fee paid when you file a prevailing wage. There's no fee paid when you file an LCA. There's no fee paid when you file a perm. So because it is publicly funded, that means when the funding goes away, the process stops. So the big impact is we cannot submit new LCAs while the shutdown is going on, and we cannot get LCAs that have already been submitted to be approved. So if you submitted an LCA 2 days ago, normally takes 7 days to get that LCA certified. If we're in a shutdown by the time that 7th day rolls around, nothing will happen. It will not be certified. So that can impact really people who are filing transfers and didn't get their LCA certified before today. And people who are filing extensions who are nearing the end of their I-94 and didn't get the LCA in time to get it certified for today. Those are the biggest impact. If you have your LCA, you can still file your H-1B, your E3. Everything else with USCIS can continue to be filed because everything we file with USCIS comes with a fee. It's all fee-based, meaning that the fees you pay fund the operations to adjudicate the application that you filed. So you can still file H4, F1, EADs, APs, 485s. Everything can be filed except those things that need a LCA. The other big impact is perm. If you are waiting for your prevailing wage to come through, you will not get it during a shutdown. If you are getting ready to file your perm and you've not done it yet, you will not be able to file it during a shutdown. And if your perm is pending, it cannot be approved during a shutdown. So that really impacts people who might be nearing their 6-year limit. Because there might be longer delay than usual in getting the perm processed on time. Typically, when we see these kinds of shutdowns, after things reopen, USCIS usually announces that they will accept certain filings late if it was due to an LCA certification issue. Labor Department usually will say, we will accept perm applications even if your ads expired, if the expiration was due to the shutdown. But how does this impact people going for visa stamping? Can I still get the visa issued? Can I still enter? Where are we at with that?
I think so. Visa stamping is still fee paid, so should be okay in getting the visa stamping and coming into the country, though. I don't see that should be a problem at this point of time. Emily, correct me if I'm wrong.
Yeah, and then coming into the US TSA, that is not really funded by fees, but it is considered to be infrastructure, essential personnel. So that will still be done. It might take longer than usual because they might be short staffed and only operating bare bones, but that still can be accomplished. The other big impact is E-Verify. So if your company uses E-Verify, typically they're not able to submit a E-Verify case or get the results of an E-Verify case while the government is shut down. But again, they usually will provide an opportunity for you to submit it late, with the explanation being that there was a shutdown.
Okay, let's move on to the H-1B fees, $100,000 fees. The last time we spoke, we clearly said that what the H-1B $100,000 is applicable, what it is not applicable, what is the gray area. And let me repeat that what we said, and please let me know if there is any changes. For those people who are applying H-1B from India in the new quota, this $100,000. So let's say, for example, a person, Srinivas Rao, is in India, and he's working for an MNC company in India, and they are applying for a H-1B in USA, and he will go for the H-1B stamping in in India. Definitely, this H-1B $100,000 fees is applicable. For the student visa people, H-4 people, L-1, L-2 people who are in United States, if they are applying for a change of status in United States, either previously because they have an H-1B approval or because they are going under the new quota right now, they will not be subject to the change of status to H-1B. They will not be subject to the $100,000 fees. Now, when it comes to the people who are outside United States and who had H-1B before, that means, let's say, for example, somebody has a H-1B, I-140 approval, and they left United States and they are trying to come back on H-1B, that fees may be applicable. Also, for those people who are in United States, if the H-1B is being filed after September 21st of 2025, and if they are going to outside the country to get the stamping, as long as they extend the status, change the status in the United States, the fees is not applicable. But if they are going outside the country for getting the stamping, the 100,000 fee may be applicable. So there is like black and white, and there is a gray area there. Anything changed, Emily? You've been contacting USCIS. USCIS responded to you saying that they will respond to you. Anything changed?
No, no updates from that. We do not have any additional FAQs, no new guidance, no new tweets. I think the biggest thing we have is some video, which I don't even know where it's from, of Secretary Lutnick saying that this really ultimately takes effect in February 2026, which would mean that it applies to the cap subject H-1Bs for people who are outside the US. That's not official. Obviously, this was the guy who got it wrong to begin with during the announcement, claiming that it was going to be every year for 6 years and apply to all H-1Bs and effective immediately and all that sort of thing. So
And
we don't
every
really
year it's
have any
100,000.
news. Right. Yeah. So we don't have anything official about who it applies to. I can say we have filed extensions since September 21st. We filed transfers, we filed amendments, amendment plus extension. We've never paid the $100,000 fee. We got receipt notices for the premium processing cases. So they do seem to be processing things as normal as they should. I do not believe that these cases are impacted at all by the $100,000 as long as the person stays in the US. I'm, hearing from clients sometimes that say that, if their H-1B was filed in this past lottery and they got it approved and now they're going for stamping, their attorneys are telling them don't go, the $100,000 fee applies. Or at least they're saying it's not clear that it doesn't apply. I'm not sure how it's not clear. As far as I'm reading all the guidance, it says this only affects people prospectively. It is not retroactive. And for all those people that applied in this year's lottery, all of their petitions would have been filed before September 21st. And I think all of the guidance made it pretty clear that this does not apply to any petition filed before September 21st. So I'm not really sure what the issue is, what they're concerned about there, that it would somehow apply to those people. But I do know that there are attorneys being extremely conservative about this and telling people, no, of course, we've already told people don't travel, especially if you need visa stamping. But I think it's not anything related to the $100,000 fee for that, why people shouldn't travel. It's more just the possibility of additional travel bans, the 221Gs, extreme vetting, and that sort of thing.
Emily, if the H-1B petition has been filed before September 21st, where it's been a change of status from F1 to H-1B, and you're telling that if they go for stamping in India at this point of time or any other country, they are not applicable $100,000 fees. I even spoke with some of the people who have attended the interview after September 21st, had no problem. Nobody asked them $100,000 fees at all. However, if somebody is applying for a change of employer after September 21st, and they got their H-1B approved, and the change of employer has been filed after September 21st, and they are going to go for stamping, is the $100,000 fees applicable?
That's where we don't know. And so I would caution those people not to go for stamping until we have official guidance on that, because it is an entry ban and it is a petition filed after September 21st. So based on the plain language of the proclamation, it would appear that that person would need to have the $100,000 paid. I think the intention behind the proclamation was actually meant for the lottery, as Lutnick said, February 2026, meaning next March, April lottery. If that's the case, why the heck did they feel the need to announce it in September 2025? I don't know. Maybe just to cause chaos and scare people, or just to let their base know that they're doing something, even if it doesn't take effect right away. The timing of it is definitely suspect, but I'm hopeful that it really is intended to take effect for next year's lottery, and that there'll be, number one, some guidance, but number two, some litigation that blocks this whole thing, because it's just the president doesn't have the power to require $100,000 payment to get an H-1B, for sure.
There are some flyers issued by American Immigration Lawyers Association, and seems to be that some other people also did send the flyers. And a lot of people are under the assumption that the change of status from one status to another status, even if a person is on a B2 right now in United States, and he already has a H-1B from some other company, the fees is not applicable. I don't know how they are reading those particular questions that the flyers that were being put out for American immigration lawyers and other people, and they are saying that it's applicable. When I read the flyer, I don't read it that way though. So the flyer is correct, but the interpretation is wrong.
Yeah, I mean, just the plain language of the proclamation, it's an entry ban. How can they block a change of status? It's not an entry. I just don't see it that way. And they make it very clear that the only decisions that they're going to restrict from USCIS are those where the beneficiary is currently outside the United States. I mean, that's very clear. If you're currently outside the US, then this applies. So I don't see how they can apply it to a change of status for someone in the US. Now, if they later travel, that's where the question opens up. But I would have no problem filing a change of status for someone today without the $100,000 fee.
So the essence of the theory, I would say that for the people who know Indian language a little bit there, we call it as Lakshman Rekha. That's what, never cross that. The Lakshman Rekha here is that there's a line that you should never cross. That's what we call MLAs. So the line here is the border of the United States. As long as you're in USA and you're not leaving the country, whether you are extending the status, you're changing the status, you're amending the H-1B, this $100,000 is not applicable. Even if you are in the new quota That means you're filing in the October of 2020, 26 start date, which is going to be 2027 quota. That $100,000 is not applicable. The border is where you need to read. Don't cross the line. That is the line. The border of the United States is the line. Now, if you are extending the status after September 21st, change of status after September 21st, or change of employer after September 21st, and you are crossing the border and you're trying to come back into United States, either with automatic revalidation or you're going for stamping, either of those things, we are not clear at this point of time. We would just say that it may be applicable at this point of time. So we want to be careful on that.
All right, you want to move on to the next topic?
Birthright citizenship. A lot of people are really tensed at this point of time. Right now, there is an injunction which has been issued by the district court and later supported by the circuit court, Emily, where if the person is born in the country right now, even today, on September 30th of 2025, they can get the birth certificate, they can get the citizenship. We had no problems. Nobody ever called us saying that they are not issuing the passports to us, they are not issuing the birth certificates. We already told all the people, please get their birth certificates and passports ASAP so that you don't have a problem at a later date. Now, the Trump administration went to Supreme Court to get his executive orders. The Trump administration wants this one to be taken by the Supreme Court, and he wants Supreme Court to decide whether or not his executive orders are according to Constitution. That's what he requested the Supreme Court. Emily, can you tell me when this can happen? The Supreme Court will take up this case or will not take up this case? If it takes up that case, how long it's going to take it, and what the decision can be?
Yeah, so as far as we're aware, the Supreme Court has not yet decided whether it's going to take up the case for this upcoming term that starts in October. If they do, we can be looking at oral arguments late winter 2025 or early spring 2026, and then a decision issued maybe within a few months after that, maybe by summer 2026. So we don't know yet whether the Supreme Court is going to take it up right now, or if it's going to go through the normal process of making it up to the Supreme Court. If they do, then we could hear something within the next 6 to 8 months and get an actual decision on the merits of the case. Because we did already have a Supreme Court case that didn't actually touch the birthright citizenship issue, is only about the nationwide injunction issue.
So at this point of time, things are continuing. You're going to keep watching the YouTube channel until we tell you. We will give you updates. Emily, let's go to the question and answers.
All right. All right. Butik says, if people are going for H-1B renewal stamping, does the $100,000 fee apply? I think it depends on when their petition was filed. It's very clear that their petition, if it was filed before September 21st, 2025, according to all of the guidance, this executive order does not apply. Only petitions filed after September 21st, 2025. If you then travel and go for stamping, we do not have clear guidance on whether it will be required or not.
Aarti has this question. She got the green card 2 months ago. However, she's laid off right now, and she wants to travel to India. She does not have a job, but she has a green card holder. I mean, when you get laid off and you have time, people like to travel. Nothing wrong with it. So the first question for her is that a problem that she doesn't have a job and she's traveling? Absolutely not a problem at all, Aarti. Absolutely not a problem. You can travel. I'm hoping that you will be traveling less than 6 months. So as long as your stay is less than 180 days outside the country, I have no problem, none whatsoever at all for you traveling. And Aarti has already had the green card. So please, this is only for the people who are green card. She has the next question. If I apply for the unemployment benefits, will it affect the citizenship application? No. If you are unemployed and you're applying for the unemployment benefit, if you're a green card holder, it does not affect the citizenship application. You are good. It's not considered as a public benefit. It's more like a health insurance that you are claiming it back, though. So I don't see that as a problem.
All right. Sumit says the change of status from F1 to H-1B was filed in June 2025, so this past lottery, still pending. On-STEM OPT that's valid till December 2026. With the recent proclamation, is it a good idea to upgrade to premium processing now? Is there any negative effect? Well, the proclamation does not apply to you because your petition was filed before September 21st, 2026. It may be a good idea to upgrade to premium processing more because the longer this case keeps going, you never know what tomorrow brings in terms of your job. What if you lose the job tomorrow and your company withdraws the H-1B? Now you've got to go through the lottery next year and deal with the whole new lottery system that we might have to deal with, where if you're a level 1 wage, you're only going to get one shot. Level 4 wages get 4 chances. So it may not be that you'll make it through again. So you might want to consider upgrading to premium processing for that purpose so that you can lock in the fact that you've been counted in the lottery.
I mean, I'm going to answer this question, but I just want to make sure if I did anything wrong, I want you to correct it. I know you keep reading the questions, and I'm answering the question just like I do. My parents are coming on US on October 25th. Does this visa integration fees applicable for them? The answer is no, because they already got the visa stamping. Since they're just entering into the country, they will not be asked to pay the $250 per person. Am I right, Emily?
Yes, absolutely. Let's see. AP says, and also Shan says, any news on the physician exemption for this $100,000 fee or any lawsuit? No news. There is no exemption announced yet. We have no idea what the national interest exemption will entail, how do you apply for it, who makes the decision on it, whether it will be granted to the individual, whether a company can get it, how an entire industry can get it. No discussion of that yet at all. Perhaps that's because this isn't really impacting anyone until February 2026. We'll see. But in terms of lawsuit, nothing's been filed yet. There are definitely lawsuits in the works, getting ready to file, working out all of the legal arguments, as well as trying to figure out who's going to be the best plaintiff to make it as strongest case as possible. So I do expect there to be lawsuits, and we'll have to see if there's actually going to be a physician exemption.
DG is a physician. He has a H-1B stamped until July 2027. Can I visit my family during Diwali in 2 weeks? The hospital is being cautious, tell me to avoid travel, but he also said you should be fine. We are saying it's fine, absolutely not a problem. We had people like you who traveled after September 21st, had no issues. We were a little bit skeptical on September 21st. Definitely we were. It took a little bit while for us to get the things very straightened up, but we had a lot of other people under the same situation, DG, that who had stamping, who traveled after September 21st and keep traveling. We never got any call from anybody saying that somebody is asking $100,000. And if we do, we will report it. We have no hesitation in reporting it.
PS says my priority date was current, then retrogressed. Now it's becoming current again. And the only thing pending from my side is the medical. Can I submit the medical now before an RFE, or should I wait for the request for evidence? You can definitely submit it now through what we call interfile. We do have an article on our website, rnlawgroup.com. Search for interfile. It will give you instructions on how to do that. I do recommend that when you go to the doctor to get the medical, get 2 sealed envelopes with identical medicals in it. Send one through the interfile process, keep one in your back pocket in case it never makes it to your file and you get an RFE, or they cross in the mail, or you get called in for an interview. That way you can respond to the RFE or bring it to the interview. You don't have to go back to the doctor again.
Saheli Paul from Facebook has a very interesting and legal question. What she has a question, what this person has a question is that if I transfer from company A to company B after September 21st, is this $100,000 fees applicable, especially when I'm going to go for US stamping outside the country. We are not sure at this point of time. We are cautious at this point of time. Since you're filing the H-1B transfer after September 21st, though, we are not, it's a gray area because there is a lot of confusion when we got the news in Bloomberg, when the news release was being done by when Trump was sitting. We have seen the Commerce Secretary telling that it's applicable to everybody, and everybody with every year they have to pay $100,000 fees. Then we have two statements given by the two Twitter statement given by the Trump administration. We have the USCIS given a statement. We have the CBP given. When we put all together, though, we are at this point of time unable to determine if this $100,000 is applicable if you apply for the change of status and go outside the country and come back into the country, though. We know for sure if you move from company A to company B, even after September 21st, and this fees is not applicable. We know for sure. However, the question is that if you apply the H-1B after September 21st and you leave the country and you apply for the visa stamping, is that $100,000 applicable? We are not sure. When we are not sure, what we normally tell, don't travel until we get the decision. We will see the scapegoats. If you want to be the person who want to be the example of it, go do it. We'll say, hi, Saheli got stuck there. They asked $100,000. Then we'll tell everybody else, don't do that. Or if you successfully come in, we'll tell she successfully came in. So right now, until we know it very clearly, we will take caution and we'll say, don't travel.
AR says lost the job while on H-1B, but have a valid AOS EAD and advanced parole till 2029 based on my spouse's 485. Do I need to update anything or do I automatically move to the EAD? So you do have the H-1B 60-day grace period, assuming that your I-94 has not yet expired. After the 60 days, if you have not filed an H-1B transfer or a change of status to something else, then you lose your H-1B status, and now you are staying in the US in adjustment of status based on your pending 485. And if you then go to work, you would use your EAD card. So it's, yes, kind of automatic. You don't have to do anything. It's just whenever you find that next job, you'll give them your EAD card to fill out the I-9 instead of having them file an H-1B.
Really interesting question from Vinu Matthew. Do we need to pay $250 if I'm traveling in H4 EAD with valid stamping to USA? If you already have a valid stamping, you don't need to pay the $250. What about, Emily, if I am going there outside the country to get the H4 extension stamping? Do I have to pay the fees?
Great question.
Yeah. The
I
question
think
is,
yes. I think that you are applying for a new visa. There's no really such thing as a renewal of a visa, although yes, you're applying again in the same category for the same everything. I have a feeling it's going to be applied for any visa stamp for them to issue it, but that's a guess. Somebody asked, is the $100,000 fee applicable to cap exempt jobs? Yes, it is. If it's filed after September 21st and the individual beneficiary is outside the US at the time of filing. So those are the exact, and assuming cap exempt, you mean nonprofits affiliated with the university, government research organizations, that sort of thing. So those are the only people impacted today by this. Now, have we seen anyone asked to submit $100,000? No. I don't know if that's because cap exempt employers are holding off their filings until we get more guidance or until they can find out whether they qualify for an exemption or not. But yes, that is applicable to someone if the beneficiary is outside the US right now.
a good question from Vamshi comes in. EB5 versus gold card, 1 million versus 800K, giving treasury versus investing in a business. Why would somebody prefer a gold card? First of all, there is no gold card, guys. Just because the President Trump says something doesn't mean it is there, guys. It's just an imaginary thing, though. There is no gold card, okay? The gold card is something you can buy in a jewelry shop that doesn't cost you $1 million. I think so. It cost, I don't know, maybe 1,000, 2,000, 3,000, something like that. The price of the gold went up. There is no gold card, guys. It is an imaginary thing at this point of time. And the Trump administration said he want directions from the administration to implement certain things. So practically there is no gold card at this point of time. So when the gold card comes in, we will give you more description. He vaguely said gold card only to put advertisement, the news channels and all those things, but the inner details are not there at all. He says now it's an EB1, it's EB2. I don't know what he's speaking. I mean, well, EB2, Indian nationals will have to wait for, even though its waiting period is 12 years, if you file right now, the waiting period is 150 years. We told you if you apply in 2025, it's going to take 150 years. So yeah, who's going to pay $1 million for getting green card in 150 years? I don't think so. You'll be alive. I guarantee that. If you are there, you come back. I won't be there to see.
Scuderius says, when would it be safe to travel? Very good question. And my answer is maybe January 20th, 2029, when we have a new president, assuming the new president isn't even worse when it comes to immigration.
Did you receive any extension receipt notices, transfer receipt notices? Yes. Filed after September 21st. This question is from Ahmed Omer.
Yep.
Several other people are also asked this question. Yes, for transfers, amendments, for extensions, we did receive the receipt notices. Did we receive any approvals? I don't think so. We did, but probably we will receive it end of this week or next week.
SK says, in that proclamation, they also mentioned that they're revising the prevailing wage. Are there any updates on the proposed changes? And would the administration go back to last term where they did level 4 to level 1 wage? So we do not have any updates yet on what their plan is or timeline for that. You're correct. During the previous Trump administration, they did basically recalculate all of the prevailing wages. And so when they updated the prevailing wages on July 1st of whatever year that was, they came out completely different. There was a lawsuit and it was eventually enjoined. And then by the time the Biden administration came in, it all went away. And so we don't know if it's going to be similar to that, if they're just going to recalculate kind of where the levels fall within the 1 to 4. All I can tell you is expect that they're going to try to make them higher. I think that's a given.
Okay. I was trying to look into any approvals for the premium processing. Dependent
None yet.
Yeah.
I've been watching.
Okay. Dependent on AOS EAD, can I apply for unemployment benefits? We used to say yes before, but we're a bit reluctant right now, though. If you have not gotten the green card, if you're an H-4 EAD, if you're an adjustment of status EAD, even though you're a dependent, I would rather stay away from the unemployment benefits.
SB says, whatever's being done by executive order, is it going to be a part of the process forever? Or if a different administration steps in, will it be overruled? It will change as the new administration comes in, assuming the new administration doesn't like it. So you would have seen at the end of the prior Trump administration, when the Biden administration came in, they immediately undid multiple executive orders of the Trump administration. Some of them took longer. Some of them took longer for unknown reasons and really shouldn't have, but eventually all of the Trump executive orders were undone. Then Biden started issuing executive orders, and when Trump came in, he said, nope, we're not doing any of that, and he undid all of those. So yes, every 4 years it's going to be a back and forth, just depending on whether immigration is a hot topic at that time for that administration.
No wonder immigration lawyers make money, Emily, and it's so confusing.
Right.
Okay, questions. Does USCIS conduct green card interviews if the government shuts down? Well, USCIS 485 interviews will continue, though. We do not expect any problem because it's a fee paid. You paid a lot of money, $1,000 plus you paid for the 485. So based on that, the USCIS is running, so shouldn't be any problem in interview.
Antu says, I'm on H1, my wife's on H4. Their oldest daughter is a US citizen and turning 21 in 3 years. However, their younger daughter is on H4 and will be 16. How do we file the GC? So, yeah, for immediate relatives, so as the parent of a US citizen, there are no derivatives allowed, meaning dependents are not part of that process. So that means your daughter, who's the citizen, will file one case for you, her father, one case for you, her mother. And for her sister, she can only file F4 sibling case. Not sure what you would do with the H4. She might have to switch to an F1 to finish her school. I don't know. You have any thoughts on that? Have you come across someone in that situation yet? It's definitely going to become common.
Emily, I didn't pay attention. I was reading the
Oh,
question.
sorry.
Um,
This is a US citizen child turning 21, so we'll be sponsoring each of her parents, but they also have a younger daughter who's on H4. So there's no derivatives for immediate relatives. So what does the younger daughter do?
the way that I normally do, Emily, is I have one parent move on to the green card. They one parent to stay with the daughter so that the daughter will be an H4. And I have this one parent file under the F2B, F2A category. You see
Mhm.
my point?
Yeah.
Yeah, it's a
Yeah,
very
because
clever
then
strategy.
derivatives are allowed. Yep.
Then, so because if the sister files for the sister, it's going to take 21 years. The sister is going to,
Right.
yeah, that's not. So what I do is if two parents are there, if two parents moves to the green card, this kid will become illegal. What I do is that I get one green card for one parent and let one of the parents stay on H-1B and the kids stay on H-4. The parent who got the green card will in turn, once I get the green card, apply for F2A. I've done that successfully though.
I
So I
have a
like to,
feeling that's going to be more common as more US citizen kids turn 21, sponsoring their
yeah.
parents.
Yeah, but typically, though, it's not the elder sister who will be the US
Yeah,
citizen. It will be the younger
it's the
sister who will be the
younger.
US younger sister. So, if since the elder sister is a US citizen, it becomes very easy for me to do this kind of switching things. And I've done for one family. They felt so happy when they came to me, and then I expressed, and I did all the paperwork for the mom, and then mom I did for the daughter, and then daughter got the green card. And once we applied the adjustment of status, the father also was applied for the adjustment of status too. And it was a good deal. And I mean, I felt so happy doing the case though. Uh, uh, one second. H-1B exchange within United States is not considered to be subject to $100,000, guys.
Yash says, can you talk a little bit about the Senate bipartisan bill H-1B and L-1 Visa Reform Act? Um, if it's the bill I'm thinking it is, honestly, I have not looked at it because I think it's the same thing. This bill has been introduced every year for the last 10, 15, 20 years. Every year I can remember practicing, and it never goes anywhere. So I'm going to assume the same is going to happen this time around. Nobody in Congress is going to do anything because midterms are right around the corner. So I don't expect it to go anywhere. There's going to be lots of immigration bills you're going to see flying around, and there always are, but that doesn't mean you have to be worried about all of them. So we'll let you know if it looks like it's something that to be concerned about as if it actually gains any momentum.
Jitendra has an interesting question. Is it advisable to do the H-1B extension in premium processing? Maybe if you file way in advance, though, that means 6 months in advance. If the H-1B is approved within 4 months, I don't see any problem with it. But if you see that let's say, for example, your H-1B is expiring in April, and now in October you can file for the H-1B extension. and you are in February and the H-1B's extension is still not approved, I will convert it to premium processing. People can file in normal processing and convert into premium processing at a later date. Now, the reason why it's important to get the decision before the expiration is that, let's say, for example, if the H-1B gets denied in the month of February or March of 2026, so what do? You file an extension. Again, you can file it. Absolutely not a problem. Oh, last Trump era, we did so many of those things where the decision came earlier, and then we filed second extension. Now, the Trump did last time, one other thing the administration did long in the previous time, he shut off premium processing for H-1B at that point of time. That became a nightmare for us because we file H-1B extension 6 months, they don't approve it. It goes all the way to May of 2026. I mean, after the H-1B expires, and then we get a denial. We have to send him back to the home country and get him stamped again and come back into the country, which in this case, at this point of time, if you have to go back outside the country, we don't know if this $100,000 is applicable. So for all good reasons, that $2,800 that you pay the premium processing is worth. And if I were you, I will do premium processing. If I don't have this, premium processing fees can be paid by the employee. If I don't have the money, I won't eat in McDonald's. I will cook rice and beans, but I will pay the $2,800 and get the premium processing done.
Vamsi says EB5 versus the gold card, $1 million versus $800,000, giving it to the treasury as a gift versus investing it in a business. Why would someone prefer a gold card? You're exactly right. At least with EB5, you are investing it with the opportunity to get it back, maybe make some money, probably not, but at least unless the investment fails, you're going to get that money back versus giving a $1 million gift. Also, EB5 for India, that's the only category that's current right now where you can actually file the 485. If you're filing for a gold card, which doesn't yet exist, so you can't, but if you filed for that today and gave the government your $1 million, you can't file a 485 yet, even in EB1 if you're from India, because there's a backlog in EB1. So yeah, I don't think this gold card provides much of anything.
At least at this point of time. Later on, when the gold card develops into a certain thing from a law, where you're absolutely sure that if you pay $1 million, you are going to get the green card, I mean, unless you have some criminal record. I may not have a problem paying the $1 million because EB5 is a little bit more complicated. It's not like if you just invest $800,000, you're going to get the green card guaranteed. There's nothing like that. There are a lot of hurdles that you have to cross. But at this point of time, at this stage, the gold card is an imaginary thing. What Trump is telling, there is nothing real in that thing. Okay.
Sachin says, when you switch employers, is it technically a transfer or a fresh visa not subject to the cap? So we don't know what they mean by new petition in this proclamation because that term does not exist. However, if we are going by the I-129 form, there are different boxes that you check depending on what type of H-1B it is. If you are filing for a transfer, you check the box that says change of employer. You do not check the box that says new anything. If you are filing subject to the cap, you check the box for new employment. And then you check another box saying whether you're going to notify the consulate, meaning you're going to pick up your visa at the consulate, or you're requesting a change of status. So if you're filing an extension, a transfer, an amendment, amendment plus extension, none of those check the box for new employment. And if that's what they mean, so I don't see a transfer as a new H-1B at all. You're already in H-1B, so it's not a new petition.
Ashbrook has this question. I'm an H-1B with I-140. My daughter is turning 21 next year. Should I file a change of status to F1? Absolutely, you should. You should file it right now. And people have this question to me that if my child moves to F1 visa, can I convert her to adjustment of status if she is under 21 under the CSP age? Can I still file the adjustment of status if she is an H1 and F1 and not an H4? The answer clearly is yes. The child doesn't have to be on H4 L2 visa to file the 482 application. Even if they are F1, absolutely not a problem to file the 485.
SG says for a B1, B2 visa, the fees are already paid, but the appointment has not been scheduled yet. Will they need to pay the $250 at the time of the appointment? Based on the language of the bill, they would pay it at the time the visa is actually issued, not necessarily at the appointment.
Yeah, the question is same thing. Dito Matthews has question. It's already booked on October 3rd week. Is this visa integrity fees is applicable? Seems to be yes, it is applicable. Even though you booked it before, the law is implemented on October 1st, which is going to be tomorrow. So it is applicable. They should be collecting the $250. Question on Fawad Khan. If the person get laid off on GCEAD, that means 485 pending, and if he joins another employer, does he need to file a new I-485 petition again? I'm assuming that you are leaving the job after 180 days after you have filed the 485 application. No, no 485, no new 485 need to be filed. In certain cases, when there is an RFP or when there is an interview, you need to file the I-485J supplement. That is not like filing a new 485 application. No filing fees. The company doesn't need to have a labor certification I-140 of their own. They can use a previous company's I-140 and then file I-485J. And it's not mandatory. It's only mandatory when it's an RFP or when there is an interview. So if you move from company A to company B, and you are in a similar job, you don't have to file 485. You may, in certain circumstances, file 485J supplement.
Batman says, I filed a FOIA for my I-140 petition, and USCIS did not provide me with the approval notice. Instead, they just gave me a copy of my labor certification and the filed I-140. How do I get the approval notice through FOIA? You can't. They don't provide that. Only your employer can provide you with the I-140 approval notice. If they've lost it, they can file an I-824 application to get a duplicate, but only the company can do that. But you don't need it. You've got the FOIA. That's good enough for you to submit anything in the future that you need to submit.
Okay. This question is coming. Shell programmer, F1 to H-1B fees applying in the next quota and October 1st lottery of 2026. Is this $100,000 fees applicable? If you are in United States, you are applying for the change of status in United States, and you're not leaving the country from F1 to H-1B, the $100,000 proclamation is not applicable.
Math Magic says, will USCIS still conduct green card interviews if the government shuts down? Yes, USCIS really does not get shut down due to a shutdown, again, because it's funded by the fees, not funded through Congress. So yes, they can still conduct interviews even during a shutdown.
An interesting question from Sarvesh Pimple. If my H-1B extension is approved, I'm still using the existing visa travel to stuff. Do I need a new visa stamping? Assuming, let's say, for example, your H-1B is expiring in February of 2026. You already filed an extension. You got the extension until February of 2029. Can you travel before February 2026? The answer is yes, you can travel, but make sure when you come back, you show the H-1B approval. Make sure the I-94 has been given until February of 2029. Check the I-94. Don't check in March of 2026 to find out that your I-94 has already expired. Check it. One other thing, if your extension is been filed after September 21st, we are recommending at this point of time, do not travel. If the extension, H-1B extension, has been filed after September 21st, the line that you cannot cross, from the beginning, what I said is the border of United States, that if the H-1B application has been filed after September 21st, even though it's an extension, even though you already have a stamping until February 2026, even though you're coming back within February 2026, we at this point of time are not clear whether the $100,000 is applicable. So when we are not clear, what do we say? We say don't travel.
Senthil says, my son is 20 years old and going to college on the H-4 visa. We also have the green card and EAD, but have not been using it yet. He wants to know, can he use the EAD instead of applying for a student visa? And can I continue on my H-1B visa? Technically, yes, but the question would be, is his age locked so that you know that he will qualify for the 485 to ultimately be approved. If his age is not actually locked, and he uses the EAD, and then his 485 gets denied because he aged out, he can't just turn around and file a change of status to F1 at that time. He's out of status and has to leave, go for F1 stamping, hope to come back in, and all of that rigmarole. So if the age is not locked, he should switch to F1 rather than using the EAD. If the age is locked, then maybe consider using the EAD.
Balakrishna says he has a priority date of 2016 with company A. Now he is with company B. Do you suggest filing an EB2 or EB3? One thing we suggest is to file the POM labor indefinitely in EB2. Because if you file POM labor in EB2, you can use the same POM labor, either EB2 or EB3. So it becomes easier for you. You have two options. Now, once the EB2 POM labor is approved, then the question comes is, which one is better? I would take the coin toss and see heads, AB2, tails, AB3, whichever comes in, you choose it. Because it's very hard. I mean, we are seeing the priority date from 2020. Even you guys are seeing from 2020. We have been seeing for a long period of time, especially for Chinese nationals. We have seen EB2 and EB3 moving back and forth, back and forth. And from 2020 onwards, for Indian nationals, now everybody EB3 is downgraded. So what all people, EB3 is forward. What all people will do is they will all request everything in EB3. Guess what happens? EB3 backlogs. Then everybody goes to EB2. Then EB2 backlogs. It's like I've traveled in LA, Los Angeles highway. Man, I hate Los Angeles and Atlanta traffic more than anybody else. Whichever lane I am in, it doesn't move. When I see the other lane moving, I move to the other lane. Guess what? My lane gets stuck, the other lane moves. That's how the EB2 and EB3 works. This is especially applicable to the Atlanta and LA in United States.
Special cases, are you seeing less and less H-1B extensions and change of employer petitions? No, not that I've noticed. I mean, we're filing at everything the same as of this moment, no changes.
Okay. We have no clear guidance on visa integrity fees. What will happen? We don't know at this point of time. They may give the guidance if the visas were been issued after October 1st. They may collect the fees at the time when they book the airlines. The CBP may request you to pay the money, or when you enter into the country, bring a money order or something. We don't know at this point of time. And maybe because October 1st is tomorrow, so once they started issuing the visas, then at that point of time, they may request, and visas may already been started issuing in Japan, Emily. It's already
Yeah.
October 1st.
Yeah.
So yeah, but we haven't yet any news. So most probably we'll let you know, guys, in the next 2-3 days what's going on that.
All right, well, I think we're out of time for today. Thanks everyone for joining us. We'll keep you updated as we have the latest news, and be sure to sign up for our newsletter. Go to rnlawgroup.com so you get the updates in your inbox once a week, and you can always set up a consultation with us or any of our attorneys by going to rnlawgroup.com.
Thank you very much for tuning.